question. Do you have a written record of the beneficiary on your life insurance policy? How about the beneficiaries on your bank accounts? Or maybe you have beneficiaries or TODs, PODs on brokerage accounts. Of course, you probably have them on your 401k and your IRA. And do you have a written record of the beneficiary on all of those different assets? I talked last week about clients who are using beneficiary designations to avoid probate. And again, beneficiary designation, TOD, which means transfer on death, POD, which means payable on death. For purposes of our discussion, they're all the same, where you put somebody else on the account who is to receive it at the time of your death. And it might be that you're using the beneficiary designation to have an account go directly to that person or those persons. Or in many cases, we are now recommending that clients use beneficiary designations to fund their trust. So the beneficiary, for example, on a bank account might in that case be your trust. Again, using the beneficiary designation to avoid probate so that the account ends up inside the trust and then will be distributed as part and parcel of your trust. Well, make sure, and it seems so basic, and perhaps it's because an attorney, we're always concerned about documenting things, but make sure that you get written confirmation from your bank, your broker, your life insurance company, etc., of the beneficiary designations that you have. I can't tell you the number of times that Amanda and I will sit with clients or prospective clients going through a list of the assets, and we will ask them, do you have beneficiaries on the bank account? And oftentimes the answer is, I think so. Or do you have beneficiary on your brokerage account? Well, I think I did. Do you know who that is? And inevitably the answer in most cases is no. Make sure that you have written confirmation of your beneficiary designations. And there's really a couple reasons for that, not the least of which is after you die, someone needs to know that there are beneficiary designations on these different assets so that they know who's supposed to get them. That information on beneficiary designations is certainly something that you should keep with your estate plan documents so that the person or persons that you have tasked with settling the estate will be able to readily find it. That's the first and perhaps most obvious reason why you should have written confirmation. And certainly another reason for having that is when you come to see someone like us and we ask you, do you have a beneficiary? It's certainly helpful if you're able to pull that form out and know exactly who the beneficiaries are so that we know that as part and parcel of putting together your estate plan. But there's another reason that a lot of clients don't think about and why you ought to have written confirmation of beneficiary designation. I'm going to give you a couple examples, real life situations with clients. One, client had a bank account. Not going to name the bank, but there were beneficiaries on the bank account. Over time, after several years, the bank had contacted the client after a new bank took over. So, pretty much today, you never know who's going to have your bank a year from now. But the original bank account with Bank A had beneficiary designations on the account, and the client knew that because they had a copy of that beneficiary designation. Well, when Bank B took over, the manager of Bank B contacted the client and said, hey, we'd like to have you come in and talk to you about a better account option that we can now offer you through our new Bank B. And so the client did that, met with the bank, set up the new account and said to the bank manager, I want to be sure everything is going to stay the same. You're just going to transfer everything over from the old account. Everything is going to stay the same, to which the manager said yes. What the client meant from that is that the beneficiary designations would also stay the same. However, fast forward, client dies. Estate is now coming upon to be settled. Somebody goes to the bank to get the money based upon the beneficiary designations and is told there are no beneficiary designations on the new bank account. Now, what does that mean? Well, if you listen to last week's program, you'd know what that likely means, unless there's going to be someone successfully arguing to a bank otherwise. But what that likely is now going to mean is that that account now has to go through probate because there were no beneficiaries on the account. Clearly, the client was aware and knew that there were beneficiaries on the first account. The client thought, based upon the representation of the manager, that everything would, quote, stay the same, unquote, that the new beneficiary designations would carry through, and in fact, they did not. Had the client, when the new account was set up, insisted upon written confirmation of the beneficiary designations and not simply assumed that it would have been done, the problem would not have arisen after death. Another example, client had a number of accounts with a particular broker and said to the broker, what I want to do is I want to have TODs or PODs placed on all of my accounts. Great. Broker said we can do that. Broker had all kinds of paperwork signed for the client to do that. Client signed all of that paperwork for all of the various accounts to do that, but did not realize, broker did not realize at that time that one account was missed. The client never requested, never obtained written confirmation that they could look at to confirm that all of the beneficiaries were placed on all of the accounts, assumed that I filled out all this paperwork with the broker, assumed that the broker would have prepared paperwork for all of the accounts, assumed that everything was done properly, and it was discovered after the client's death that one account was, in fact, missed by the broker. Remember, banks do make mistakes. Brokers do make mistakes. We're all capable of making mistakes. That's why it's important that if you're going to use a beneficiary designation as part of your estate plan in order to determine where your accounts are going to go and probably to additionally avoid probate, make sure and insist that you get written confirmation of those beneficiary designations. Because think about this, you're not going to be here when the time comes that becomes important. So now your representative of the estate who goes to the bank and the bank says, hey, there was never a beneficiary on this bank account. Does that representative even know that there had been beneficiaries on a previous account? When the broker says there's no beneficiary on this account, does the representative of your estate even know that there was supposed to have been a beneficiary placed on that account? If not, and because they don't in particular, what's the option going to be? The bank's going to say, go to probate. The broker's going to say, in all likelihood, go to probate, unless someone is going to be successful in arguing to the bank, to the broker, to whoever the company is, that it was in fact their mistakes. But you don't want to put your representative in the position of having to make that argument if it simply could have been accomplished by having written confirmation of the beneficiary designations. So today's message is get it in writing. Tuesday with Tom has been brought to you by the estate planning attorneys at Doyle Law PC. To learn how we can help you with your estate plan or with settling a loved one's estate, please call us today at 517-323-7366. That's 517-323-7366.